So I have the honor of presenting Professor Martin Carcieri, and I'm going to add one more thing. I'm going to leave the introduction of his topic to him, but not in the formal Q&A, but after that, when you speak to Marty, would you preface it by saying, we do want to have you come back and talk about reparations. We do want you to come back and talk about reparations. Did you all get that? We do want you to come back and talk about reparations. And it's a real honor to present Marty Carcieri.
Hi, hello. Can you all hear me okay? Can you all hear me okay? Martin, I think there's enough. I hope there are. Welcome everybody. Good to see you all. Thank you for coming. It's always great to come back here. Some familiar faces, some new faces, and I'm a great friend of this organization. So thank you for coming today. What I'm going to present today is I can't go along without plugging my book. Today's talk is actually, and I'll just do some of the background here while the handout is going around. And I think some of you will have seen this handout before. So today's talk is based on a short chapter of my book that's coming out in July. Did I mention that in July I have a book coming out? Yeah, it's called Applying Rawls in the 21st Century: Race, Gender, the Drug War, and the Right to Die. Right? So Applying Rawls in the 21st Century: Race, Gender, the Drug War, and the Right to Die. So I am making trouble in several directions, as you can tell. And one of them I will be doing today. In this book, 2 chapters are on race. I apply Rawlsian principles to questions of race. One chapter is on race policy. The other is on the constitutional law of race. And those are different, although overlapping discussions. Can everybody hear me okay? Can you hear me okay? Great. Once again, Applying Rawls in the 21st Century: Race, Gender, the Drug War, and the Right to Die. I think within a few months it'll be on Amazon. It's published by Palgrave Macmillan. It's a series of essays I've been writing for the last 7 years or so, and again, 2 chapters are on race, and then 2 chapters are on autonomy. One is on the drug war, specifically marijuana prohibition, and the other one, which I believe I presented here several months ago, is on Rawls and the Right to Die, an issue that is emerging more powerfully by the day. None of that, however, am I going to talk about today. Today, the chapter that I'm looking at is the chapter on gender. After I had published one of my articles on Rawls and race, an editor of a law journal contacted me and said, "We like your article. If you're working on anything else, we'd love to hear you, have you send it to us." And so I had been thinking about something, and I pulled it together and I sent it to them, and they liked it. And so it became an article and now a chapter of this book. So this chapter today, this chapter on Rawls and gender, is a short interlude between, the other bigger chapters. And what's unique about this chapter that I'm doing today on Rawls and gender is that I take up a question of professional ethics, which is unique among the chapters. I'm going to be talking about what's called non-ideal theory, which is more daunting than it sounds. And then also, this chapter is not really the work of a political theorist in the sense that I'm arguing and defending a thesis that I want people to believe. Really what I'm doing here is engage in a Socratic inquiry, and you'll see that by the end of it, I'm going to issue a challenge to those who would defend certain practices that I have seen for years in my line of work. So, now what I'm going to say today will upset some people. Whether or not any of them are here, I don't know. I guess we're going to find out. But this is why they give people academic freedom and tenure. By the way, I'm a full professor now. Yeah, thank you. So now I can really make trouble. Against all reason, they promoted me once again. So, yeah. So, political science, the only true science, I might add. I just love to get people's reaction to that. Anyway, all right. So. Again, so what I'm going to say is going to be perhaps upsetting to some people, but just remember that I am no conservative, not remotely. I am raising my challenge from a center-left Rawlsian position. I'm in the liberal center with Rawls. I'm not on the hard left. I'm not on the hard right. And maybe this describes some of you as well. So just keep that in mind. I am raising my challenge from a center-left position, and I think most of the people who would object to what I'm saying or asking would be on the hard left. Okay, who often have something valuable to say, but I don't think that they've got the final word any more than the hard right does on a lot of these issues. Now, I've never presented this particular chapter before, and so I really puzzled over how to present it to you today. I did not want to just read you 30 pages, of the journal article that I published, but it seems to me that to be most efficient, I will read parts of it because I wrote it carefully, and there's certain places where I say exactly what it is that I meant to say. And so you already have a bit of a sense of what I'm going to talk about. So let me read you the introduction, just very short, and then what I'd like to do is look at a couple of the principles, identify a couple of the principles in the handout I've just given you. Again, I know this is probably new for some of you, and so I will be as clear as I can be. Some of you have seen all of this stuff before, so you'll be a little bit more familiar with it. So the name of this article is Rawls and Gender Discrimination. And I begin it with a quote from the great Supreme Court Justice Louis Brandeis, who wrote about 90 years ago. He wrote, "If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy." The guy was something. If government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. So he was acutely conscious of the importance of the rule of law. So here's my introduction. I wish to raise a question of professional ethics, although it intertwines with law and politics. I wish to do so primarily within the theoretical framework created by John Rawls, perhaps the most influential political thinker of our time. As we will see, Rawlsian legislators would enact the express gender non-discrimination rule of modern civil rights statutes into law. Yet I shall posit a gentleman named Ed, who has for decades observed blatant gender discrimination in faculty hiring and other employment practices at the public universities where he has studied and taught. Such discrimination is performed secretly, and it will, in Ed's considered judgment, long continue. He thus wonders whether those in his position or at any public institution practicing such secret discrimination have a moral right within their spheres of influence to do the same in reverse. That is, do they have moral permission to secretly discriminate against members of the gender Ed has seen consistently favored in an effort to offset or counter that discrimination in some small way? Ed remains uncertain of his course of action. Had he already decided to participate in the secret gender discrimination he has long witnessed, he would simply do it, not publicly inquire into it. Yet Ed's parents taught him as a child that race and sex discrimination are wrong, and he takes the non-discrimination rule of modern civil rights laws seriously. Indeed, Ed has a stack of nearly 200 letters of recommendation that he has written in equal numbers for students of both genders. So this article explores the difficult legal and ethical issues that Ed faces in deciding how to treat others in his work. Okay, so that's the introduction. You can tell already that I'm making trouble. That's my job. Okay. So folks, let me back up a little bit, and I'll ask you to refer now to the handout that I just gave you. Let me try to get some of the important, relevant parts of Rawls in front of us today, and so that I can try to better communicate the nature of my challenge to those who defend the kind of practices that Ed has witnessed. Okay? So you may recall that from times I've come before that John Rawls argues that in an initial situation of fairness, in an initial situation behind the veil of ignorance, he argues that we would agree in that original position as a matter of social contract to two kinds of principles. One kind of principle that we would agree to as a foundation for our civil society is principles of what's called ideal theory. And for Rawls, ideal theory simply means those principles that can govern a reasonably just society. Oh, this is doing this again. I think I had this happened last time. There we go. All right, I won't touch it. All right. It's good. It's good. So ideal theory, and you get the examples of the two principles there that Rawls articulated. Rawls argues that the two principles you and I behind the veil of ignorance would agree to as the foundation for our political order are the two that you see there on the page in front of you. Rawls' answer, two principles of justice. If you and I were designing a society from the ground up, we would first of all agree that each person is to have an equal right to the most extensive total system of equal basic liberties compatible with a similar system of liberty for all. So we would start there. No matter who you are, you have the protection of this equal liberty principle. Now, political liberty is not license, is it? Everybody understands that, right? Political liberty is not license. There are always limits on liberty. There have to be, anytime you're in civil society. So Rawls says we would agree to the most extensive system of liberty compatible with a similar system of liberty for others. Okay? So that's the equal liberty principle. He's a liberal. He's in the center. He's not on the left. He's not on the right. He's in the center. He's a liberal. Right? So liberty. We err on the side of liberty, but we recognize, as the old saying goes, that your right to swing your fist ends where my face begins. Right? Liberty is not absolute. So it's a presumption of favor. We would start there. Okay. And then the thing is, Rawls recognized that there will be social and economic inequality in society. I've heard people say Rawls is a socialist. With all due respect, they simply don't know what they're talking about. Rawls is no socialist. He does not think that society is going to wind up completely equal. He does not assume that there will always be social and economic equality. So even though we establish political and legal liberties under the equal basic liberties, freedom of speech, criminal procedure protections in court, voting rights and so forth, fundamental liberties, Rawls recognizes that there will be social and economic inequality in this world, in any free society, right? Just for example, as long as there are people born into families that love and do the best that they can for them, those people are going to tend to do fairly well in life, other things equal, right? Some people are going to be far more talented and hardworking than others. So there will be social and economic inequality. So even though the first principle ensures equality where it's essential, right, in the political and in the political and legal spheres, the second principle there, right in front of you, manages inequality where it's unavoidable. So two principles. We fix basic liberties with one principle, political and legal liberties, and we manage social and economic inequality with the other principle. And you see that second principle provides social and economic inequalities are to satisfy two conditions. First, they are to be attached to offices and positions open to all under conditions of fair equality of opportunity. And second, they are to be to the greatest benefit of the least advantaged members of society. Okay, there's a lot to unpack there, and I really can't do it now, but I wanted to underscore once again, and again some of you will recall this, that in terms of ideal theory, the rules that would govern us in a reasonably just society, right? One in which most people can follow the rules most of the time, right? Please understand, in a war zone where any person you meet may want to kill you and you have to kill or be killed, these principles are not going to apply, are they? We're talking about a reasonably just society. And human beings clearly do have the capacity, at least sometimes, to live in peace and harmony with their neighbors, right? Otherwise, we'd all still be back in the jungle. And human life would be nasty, brutish, and short, as our old friend Thomas Hobbes would say. Okay. So he starts there, and those are the principles for ideal theory, to govern a reasonably just society. And yet, thorough thinker and philosopher that Rawls was, he said, we also, behind that veil of ignorance, we have to say something about principles for non-ideal theory. And non-ideal theory has to do with questions of injustice. How do we deal with a manifestly imperfect world? And so Rawls gives us a list of different topics that would come up under non-ideal theory. Principles of just war. When is it just to go to war? Revolution. When is it just to overthrow a government? Militancy. When is it just to secretly violate the law? Conscientious objection. When is it just and appropriate to resist going off to war for your country? And then the principle that Rawls brought classic formulation to, civil disobedience. And if you look over on the second page, on the flip side of the page, up the top it says civil disobedience. Some of you will recall this is how Rawls says, these are the guidelines for civil disobedience that we would agree to from behind the veil of ignorance, because civil disobedience is one form of violation of law, but if it's done the right way, it can function to stabilize an otherwise just system. Even a just constitutional order sometimes has injustice. Maybe a particular law or person is unjust within that system. And so, Rawls articulated that for civil disobedience, you see how he gets into it. We have a presumptive moral duty to obey the law, but we have a presumptive moral duty to disobey unjust laws. That's our starting point. So what's the next step? Rawls says, where the normal means of legal reform in a constitutional democracy are available, free speech, voting rights, and so forth, we have a presumptive moral duty to work through them. You can't just break the law whenever you want, right? There's a constitutional order. There are methods for advocating political change. You should work through them first. But Rawls thinks it through. He says, if the right to resist the law is still claimed, if one still claims the right to violate the law, then since civil disobedience is resistance to law within the bounds of fidelity to law, beautiful turn of phrase there on Rawls's part, and civil disobedience is an appeal to the majority's sense of justice, then resistance to law, violation of law, can be defined as civil disobedience and claim its moral legitimacy only if certain conditions are met. And the thing that I would point you to in particular is that, and this is in accord with Henry David Thoreau, Mahatma Gandhi, and Martin Luther King, if your violation of the law is to have the moral legitimacy of civil disobedience, it must be done openly with a willingness to accept the punishment. Do you see that? That's point C under civil disobedience. The resistance is performed publicly. So I think that a lot of you see where I'm going by now, right? I've described this guy, Ed, middle-aged, early middle-aged university professor, who has observed a lot of secret gender discrimination in his career. And he notices that discrimination by the institutions, the public universities that he works for, is done secretly behind closed doors. So that university may feel that it's justifiably violating the law, but it's certainly not engaged in civil disobedience, as Rawls defines it, right? Because it's being done secretly behind closed doors. So we have a concern. And the issue arises, what is Ed allowed to do? He observes that this institution that he works for has long been discriminating whenever it can based on gender, in violation of the civil rights laws. What is Ed allowed to do in response? Anything? Is Ed allowed to do the same thing in reverse? To discriminate against, secretly within his sphere of activity? Is he allowed to discriminate against those groups or that gender that he's seen consistently favored? So this is the question that I raise here. And again, you can already see, I think, how it would upset some people, you know. And again, remember that not only from a Rawlsian approach does violation of law have to be committed openly with a willingness to accept the punishment, which his university is not doing, but principles of civil disobedience are principles for individuals, not institutions, not governmental institutions. Principles of civil disobedience are designed for individuals like you and me, trying to decide whether or not you and I will resist law, resist governmental actions if we consider them to be unjust, right? A public university is a governmental institution. By definition, is supposed to follow the law. So again, you see the gap, the difficulty that Ed is dealing with here, right? The norm, so far as he can tell, is that this governmental institution secretly, systematically violates the civil rights laws. All right. Ed knows that he's just one little guy who could die any time. This, may all go on beyond him. But he wonders, within his sphere of power, what is he allowed to do? So it's a problem for Ed. And even beyond those concerns, let me get this here. There's a couple of other problems that this creates for Ed. The fact that his university secretly, consistently discriminates in hiring based on gender. Ed finds, first of all, that he is bound to tell his graduate students of one gender what, in his experience, they can expect. Even if they spend 10 years pursuing a PhD and publishing and teaching well beyond that, a university may pass them over for faculty positions if a graduate student of another gender is available. To Ed, this seems inefficient and unjust. Beyond the unfairness to the individual job applicant whose gender is used against him, as well as the students who are paying ever-increasing public university tuition costs, the deliberate choice to hire less qualified applicants based on gender undermines the quality of education at the public universities on whom employers rely for well-trained college graduates. In addition to this, Ed has found that when job candidates who have been passed over based on gender contact him to ask him about the hiring process, in their cases, the secrecy of the hiring process forces Ed to be an accomplice after the fact. He knows that he cannot disclose the crucial facts he has witnessed. This would give the candidate a basis and an incentive to sue the university, and Ed could lose his job or at least be denied promotions and other benefits as a result. So Ed's free speech and associational interests are burdened as the hiring process forces him to cooperate with and even carry out his university's unlawful discrimination. In Rawls' words, Ed is made an agent of injustice, enabling his employer to continue discriminating with impunity. All right. So, what is it that, what response has Ed gotten, you know? He has shared his concern with faculty colleagues, and he's found that this is a very divisive and controversial subject for some people. Those that he's talked to who support gender preferences in faculty hiring often feel strongly about it and take firm exception when opponents raise certain questions, even in the most delicate of ways. Some of them tell Ed he's mistaken. He's witnessed neither lawlessness nor injustice. They assure him that the university can do what it does because graduate students of one gender, precisely due to their gender, are simply better qualified than experienced, well-published PhDs of the other. As Ed recognizes, such paternalistic dismissals have long been among the tools of totalitarian regimes. However, other colleagues concede, they admit, that had the genders of the leading candidates in the searches that Ed has witnessed been reversed, the hiring outcome would have been different. And that alone establishes what's called a prima facie violation of Title VII of the 1964 Civil Rights Act, a federal law that commands non-discrimination against any person based on race, ethnicity, gender in hiring, private firms with 15 or more employers. Okay. But these colleagues who admit, you're right, Ed, okay, the outcome would have been different. You know, we did discriminate, but colleagues assure Ed that their university is allowed to act in this way for three related reasons. First, the university needs something called diversity. Second, one gender is underrepresented on university faculties. The third reason they give for secret discrimination based on gender is that students need role models who look like them. So diversity, underrepresentation, role models. Ed is familiar with such rationales for the discrimination he has long witnessed, yet he perceives several difficulties with them. Now, my response to those is going to take up several pages. So I'll be glad to come back. Let me, just to make sure I get the whole thing in front of you and give you a chance to ask any questions that you have, let me fast forward a little bit. And I'll just say that Ed ultimately concludes that the diversity, proportionality, and role model justifications do not justify the secret lawlessness he has seen. So, Rawls writes that we have a natural duty to cooperate with reasonably just institutions, those that reasonably adhere to the two principles of justice. However, in Ed's long experience, public university faculty searches seriously deny not only legislative guarantees of fair equality of opportunity, but also constitutional essentials like equal protection of the laws. These are, again, governmental public institutions. Since such lawlessness situates us at least partly in the realm of non-ideal theory, those who support this gender discrimination may claim it to be within the noble tradition of civil disobedience. You know, we're violating the law, but we're doing it, in accord with civil disobedience, but you already know the answer to that, right? We know that while violation of law is sometimes morally justifiable, it is civil disobedience only if it's done openly with a willingness to accept the punishment. So if those who support the secret discrimination Ed has witnessed really were consistent here, they would put in the ads exactly what it is that they're saying. Only members of one gender need apply, and they would be willing, indeed eager, to defend what they're doing in court. They should be willing to argue before a court of law that the express command of the civil rights laws, it should be unlawful to discriminate against any person based on race, ethnicity, gender. They should be willing to argue that that's an unjust law. They should be willing to argue that public universities must be able to discriminate based on gender as they see fit, for whatever reasons, diversity, proportionality, whatever. They should be willing to put their money where their mouth is, right? But in Ed's long judgment, this is not going to happen. In Ed's judgment, public universities, including the one that he works at, will continue to discriminate secretly as long as they can get away with it. And so, again, Ed is he's in a tough position. And he's very doubtful at this point. You know, he's a good liberal. He's willing to listen and to be talked out of his views, but he's looking at some very disturbing facts here. So let me go to the next level into it. One of the difficulties that Ed has with this university faculty secretly using gender, discriminating based on gender, hiring people who never would have been hired but for their gender compared to the other applicants. Ed knows that every single one of those public university professors was at one time himself or herself unemployed, on the job market, looking for work. At those times, Ed observes, every single one of them would have justifiably claimed the fullest protection of the civil rights laws, the right not to be disfavored based on gender or race. And yet, Ed observes that once such candidates are hired, and they are accorded that right in the searches that got them, right? They applied for a job, they got the job. Therefore, enough people did not discriminate against them based on gender that they got the job, right? Once that happens, they simply discard the obligation to treat others fairly or similarly and impose on them what they would never consent to themselves. Once they've got that job, now it all goes out the window, right? Newly hired faculty seem to undergo a transition from a mindset of reciprocity and mutual advantage, which is characteristic of the golden rule in the social contract, toward a posture of might makes right. Might makes right. Whatever we can get away with, right? The view becomes that they are entitled to do whatever they can get away with for one gender by any means necessary. You see that? There's a shift from a convenient shift from a social contract model to a warfare model, you see? Ed sees two implications here. First, in terms of formal legal categories, it appears that in this view of those who, again, insist that the university should be able to discriminate based on gender secretly, on that view, there's no social contract, right? Indeed, it seems that those who support the discrimination Ed witnessed operate not under a contract model of society at all, but rather under a tort and crime model. People of one gender, this is the presumption, people of one gender have committed torts and crimes against those of the other gender, and each of the former now owes each of the latter in perpetuity. Every member of one gender is a debtor to every member of the other gender. Right? When such individuals who defend this hiring, when they are on hiring committees, they become judges and chancellors imposing tort remedies and criminal punishments, not parties to a social contract who control and dispense scarce, valuable public resources like public jobs in trust. This is not unjust. The reasoning seems to proceed for there has been far more suffering in this world than that of a few members of one gender passed over for employment, even that for which they prepared for years. Secondly, in Rawlsian terms, the transition from a mindset of reciprocity to one of might makes right, what can we get away with, involves a convenient shift from the priority of the right to the priority of the good. Let me come back to that, folks. That's a little bit abstract. Some of you have heard me talk about it before, but that'd take a long detour. Okay. So, it says, those who support the discrimination Ed has witnessed seem to want it both ways. Others must respect their civil rights, but they're not bound to reciprocate. You see? No social contract there. To Ed, this is literally contempt for the civil rights laws. It seems to him that a child would recognize this as cheating and free riding, as fundamentally unjust and dishonest. Ed finds that he can neither honor nor respect such a view, particularly since many on the left expressly or implicitly assume the legitimacy of the civil rights laws, like Title VII. They champion civil rights. We're all about civil rights, but in his view, in Ed's view, they forfeit any moral high ground, violating the social contract and its core principle, the Golden Rule. Okay, so let me give you the conclusion here, a couple of paragraphs, and then see what you got to say. We can go in different directions. I appreciate your sticking with me here. Here's how I wind it up in the last 2 pages, in issuing my challenge, the last 4 or 5 paragraphs. Rawls wrote, I'm so used to leaning on it. All right, I'll put my hands back here. Rawls wrote that when a person encounters injustice by government, he must decide whether to resist it, and if so, how. Like the public university that employs him, Ed can secretly discriminate within his sphere of influence in violation of federal and state civil rights laws. He can get away with it, right? The question thus arises of whether those who support the actions Ed has long observed can legitimately expect that those in Ed's positions not to do the same, not to discriminate against members of the gender they have seen favored for decades. More precisely, beyond the moral duty to tell his graduate students of one gender what they can expect in the profession, do those in Ed's position have moral permission in response to their public university's actions to secretly discriminate based on sex and their spheres of influence in order to help level the playing field? When they vote on faculty hiring or tenure decisions, for example, may they vote for or against those of one gender regardless of their qualifications? When they assign grades to students and write reference letters, may they assign lower grades and write weaker letters of reference for members of one gender than they deserve, and assign higher grades and write stronger letters for members of the other gender than they deserve? In a small effort to help offset the discrimination Ed has long witnessed? More generally, if Ed is not one of the gender he has for decades seen favored in his line of work, and if it is clear to Ed that many of that gender in positions of power are utterly indifferent to the interests of his gender, why should Ed care about the distinctive interests of that gender, say, for example, procreational autonomy? If they care nothing about his interests, why should he care about theirs? You see that? Again, it's going to be a contract, social contract, one way or the other. We're going to be in good faith or we're going to be at arm's length. You choose. These questions trouble Ed. Again, had he already decided to do such things, he would just do them secretly, not discuss them publicly. Yet Ed went into teaching to help people, not to treat them unfairly, as the positive reference letters he has written equally for students of both genders suggest. However, Ed finds it difficult to resist Professor Butler's suggestion that, quote, it would be farcical for him, Ed, to be the sole gender-blind actor in the process. You know, if everybody else is discriminating based on gender, why shouldn't I as well, right? If they're secretly discriminating, why shouldn't I as well, right? Okay. So, if Ed were to wake up tomorrow and finally conclude that he will no longer be the only gender-blind actor in the process, or one of the few, what could those who support the practices he has seen say to him? They might say that Ed's means would not be narrowly tailored to his ends, since he would be unjustly hurting innocent people. On a contractual model of society, of course, that makes sense, right? Ed's students and potential colleagues deserve to be judged fairly, based on their individual merits and in accord with the plain words of the civil rights laws. They deserve that. Non-discrimination against any person based on race, ethnicity, gender. Yet again, Ed has for years seen job applicants passed over based on gender. Therefore, like Professor Butler's hypothetical juror, Ed holds no confidence in the integrity of the system and is tempted to invoke the political nature of his role in the system, right? What can I get away with? Power, not principle, power. What can I get away with from my tribes? If those who support the practices Ed has long observed consider themselves liberals, they must not only tolerate questions like Ed's, but also welcome and engage them. Further, if they consider themselves liberals in the Socratic tradition, they must persuade or obey. Remember that famous line from the Apology, they must persuade or obey. As a Socratic Rawlsian liberal himself, Ed is likewise committed to an open mind, to listening with the willingness to be persuaded. He's not attached to his present view so much as to understanding and acting upon the legal, political, and ethical truth of his situation in all its complexity. As Socrates said to his interlocutors, in effect, With all due respect to your reputation for wisdom, I'm not interested in idle opinions or sophistic word games or mere dismissals of my questions. In the forum of public reason, then, and in direct response to Ed's many concerns, what could those who support the practices he has long witnessed say to persuade those in his position not to engage in the militant response he's contemplating? Thank you.
Okay, I'll bring the microphone.
Martin, I'll let you do the picking.
1, 2, 3.
Thank you. Very, very well thought out, very well presented.
Thank you.
So, Ed sees discrimination. Is Ed the perfect arbiter? Does the discrimination Ed sees provable, other than statistically?
Good.
And to further complicate the issue, is it in fact conscious by those performing it? And is there a difference between conscious discrimination and unconscious discrimination?
Okay, you asked me like at least 3 questions there, right? Okay. Let me take these one at a time. So one of them was, is Ed the perfect arbiter? No, he's not. Nobody is. Perfection is never the standard with human questions, right? Where Rawls starts from, again, is these principles of non-ideal theory like civil disobedience. These are what we'd agree to guide those imperfect human beings who show up in society and notice that their government is acting unjustly. Nobody's perfect. Perfection is never the standard, right? So I'm going to put that aside. The question is Ed, as somebody who wants to live by the rules, who wants to live by and agrees with the fundamental principles that Rawls has given us for a liberal constitutional democracy, what is he allowed to do under the circumstances? So in terms of its being provable, since it's done secretly, this discrimination never sees the light of day in a court of law. Let's assume Ed's a lawyer. Let's assume that he understands enough about the law to be able to judge whether, if the facts of this search, who the applicants were and who we finally decided on, were exposed to a court of law in the light of day. In Ed's firm judgment, there's not a chance the decision would go the same way, and so Title VII has been violated. So it has not been proven because it's not done openly, it's done secretly, but let's just assume Ed understands something about the law. In his considered fair judgment, if that search were exposed to the light of day, not a chance would it be legal. Okay? Now, so those are the 2 of the questions. The third one, you said something more generally?
Their consciousness of, the consciousness of the actors in their discrimination, does that bear upon the question that they are subconsciously discriminating versus actively and collusively versus individually subconsciously?
You know, again, in terms of what it would take to prove a violation of Title VII or other civil rights laws in court, that question would not matter. The question is, in this search, on these facts, would this decision have come out differently if the races and genders of the 2 leading candidates been switched, right? So it's one of the reasons I went to study law, right? There are philosophers who write entire books on intentionality, right? Whether somebody in court intended something is simply a question of fact for the jury. Put it to the jury. In your judgment, did they discriminate here, right? And so in a sense, we don't have to get into the whole question whether somebody could plausibly say that, well, I know we hired this female graduate student with no publishing or teaching experience over this highly accomplished male PhD, but no, I don't think I was discriminating. Okay, fine. Maybe you don't, maybe. But it doesn't matter, right? Objectively, what would a jury say about that in a court of law? And for me, that's where the rubber meets the road. Whatever it is that people may tell themselves about good discrimination, right? The civil rights laws command non-discrimination against any person. And Ed thinks that's a fair law. And again, he notices that every single professor who ever got a job clung to that principle, non-discrimination, like a life preserver when they were on the job market. But again, once they get that job, it's all out the window. Now it's might makes right. What can I get away with for my tribe? You see? Bad news, isn't it? So, thank you very much. Good place to start. Somebody else? Yeah.
By way of, I'm not here from the front.
Oh, you're right here. I'm sorry.
Yeah.
Everything's going.
But by way of, I was going to say full disclosure, let's say partial disclosure. In the decade of the 70s, I was an assistant vice president for academic affairs at a state university in Minnesota when affirmative action laws first went into effect. for those who aren't familiar with the academic world, an assistant vice president is the one who's delegated to write the memos to faculty to make sure they attend committees that they don't want to attend. Sometimes other things. It seems to me the real complaint here is a matter of secrecy, is one part, and the other is the legitimacy of the role model as a legitimate consideration in an academic appointment. And I really think it boils down to those. If you accept that there is a need for diversity in a faculty in terms of gender or race or...
It's a big if.
Right. Okay, if you assume that, and it certainly became a factor. That's what affirmative action was all about, it seems to me.
It's one justification that people have given.
Okay. I'd like you to talk more about just the question of secrecy. It seems to me that for the first part of your remarks, that seemed to be the real focus.
It is a big part of it, that's right, because violation of law that's done secretly is called militancy. And militancy, in Rawls, but the way that he defines it, and militancy is sometimes morally justifiable. Let us agree to that. You know, the Underground Railroad, when they help escaped slaves get to freedom up in the northern states and in Canada, they were engaged in militancy. That was secret violation of law. And I think we can all agree that they were perfectly well justified in doing that. But here's the thing to notice. In that situation, what was the relationship between the slaves and the government that had enforced laws that held them in slavery? It was not that of a legitimate sovereign to a citizen. It was that of a higher power to a lesser power. So the conditions of constitutional democracy are not in place, and so militancy is more justifiable there. I would say that in the context of faculty hiring, we're not really in the same situation that we are with respect to the antebellum South, right? So there's more to say about civil disobedience and militancy, but you're absolutely right. One of my key concerns about all this is the secrecy of it. I could have much more respect for the public, and I'm more than one that I've seen do this, that bend over backwards to discriminate based on gender. If they would just do it openly, I could respect that with a willingness to accept the punishment, you know, and to argue it in court, go into that federal court. Your Honor, non-discrimination against any person is unjust. It's unjust. You know, I'm not in a position to repeal the 1964 Civil Rights Act, but it's a bad law. We should be able to discriminate, contrary to what the civil rights laws say. And so, yeah, so it seems to me that if they really had the legitimacy that is required of this rule for civil disobedience, they would do it openly with a willingness to accept the punishment. No men need apply. No white men need apply. Don't waste our time, we won't waste yours. They're not going to do that. They're not going to do that. They will continue to do it secretly. So that's one thing. The other thing, Paul, you mentioned diversity. I've never heard a good definition of diversity. Seems to me every single person brings diversity. I think that reducing diversity to race or gender is itself a racist, sexist premise. I'm willing to be talked out of that as a good liberal, but I've never heard a decent definition of diversity. When that concept as a constitutional justification was first introduced by the great Lewis Powell in the Bakke decision, he said very little about diversity. He did not define it. Brilliant judge that he was, he thought, this is a problematic, nuanced term. I'm going to leave it for scholars and judges down the line to work this out, to develop it, to refine it. And in my judgment, as admirable an attempt as that was, we've never gotten a coherent definition of diversity. In any case, the bottom line is Title VII says nothing about diversity. It says it should be unlawful to discriminate against any person based on race, ethnicity, gender, etc. The actual civil rights laws themselves say nothing about diversity. And I'm not surprised. How do you define it? Okay. And role model. Help me with this. In this age of social media, what 18-year-old can possibly not be aware that there are plenty of people who look like him or her in prominent positions? How can that be lost on anybody, right? So the role model thing, this idea that unless a university discriminates secretly in hiring, that these students will assume that they have no future because they can't see anybody who looks like them, I just guess I would question that. You know, in every direction, they can see people who look like them who have done well. Okay, so there's probably more to that discussion, but that's one place I would start. So thank you very much. Okay, who's next? Yes, sir, right here.
Early on in your presentation, you made the point that your example, Ed's position as a faculty member at a public university, entailed the opportunity for the university to exert pressure and influence on his behavior because the university had the power of dismissal.
Right.
Right. This depends very strongly, I think, on whether or not Ed has tenure.
Yes.
And I didn't hear whether you
He's got
said that or not.
Good,
okay,
good,
I missed it. I'm sorry. Anyway, I wanted to ask about that and how you think that having or not having tenure is pertinent to your discussion.
Good.
And what are the additional obligations on a faculty member who does have tenure to resist the influence of the university that you referred to? Having had tenure myself at a private university, I'm aware of the controversy that surrounds tenure. But that's not the issue here, I think.
Very good, very good. Thank you so much. First of all, right off the bat, as long as Ed was an assistant professor without tenure, he really couldn't do it. Okay, so once Ed got tenure, he's an associate professor. At that point, he's got tenure that gives him a great deal more protection, and yet, I observe at that point, Ed, I think in a lot of academic settings, would not be irrational to fear that if he were to blow the whistle at that point, to really, to raise hell about this at that point, there's a good chance that he could be denied promotion and the salary bump that goes with that. To say nothing of other goodies like sabbaticals, right? If Ed were to raise a problem before he's a full professor like this, there's a range of things that could be denied to him, even though he's got tenure. So you raise an excellent question. And if Ed is recently a full professor, you have to ask, what the hell is his excuse now? All right, I will get back to you on that one. I really work with a lot of good people, I have to say, and I love a lot of the students that I work with. I really feel very strongly about where I work. I came up through Cal State myself, so I feel like whatever I'm going to do, I need to do it the right way. One of the things I'm doing, by the way, is talking about this stuff. This is a chapter of my book. Sooner or later, more and more people at my university are going to know about this, and so, you know, in fact, in the fall, I may be on a panel discussing this. So, but quite honestly, I did not feel until I've just this week finally got a letter from the president saying, okay, you're a full professor now. All right, now I can start thinking about maybe what I want to do about this. So, excellent question, sir. Set of questions. Thank you so much. Okay, who's next?
So I've got 5 in the line at the moment, and we got about 15 minutes, probably 10, 15 minutes just to keep things in.
All right. Yes, ma'am.
What I'm concerned is about culture. Where would you put culture? If we have a culture that promotes compassion, humility, understanding of others, sure, then our decision will come from our own conscience rather than twisted rules and regulations.
Okay, okay.
So where would you put culture?
Let me, it sounds like a very interesting question. I want to make sure that I understand. Culture as a basis for discriminating based on gender, or no?
No, we develop a culture that promotes compassion, humility, understanding.
Okay.
So that in the future, we will be good decision makers instead of depending on outside laws, which in many situations, they're biased.
Okay, okay, interesting. Sure, a lot of laws are not perfect. But you know, it's interesting, the civil rights laws that govern us, the text of Title VI, Title VII, and the California Constitution, they're precisely not biased, right? Title VII says it should be unlawful to discriminate against any person based on race, ethnicity, gender. Article 1, Section 31 of the California Constitution, formerly Proposition 209, provides that it should be unlawful to discriminate against or grant preferential treatment to, and I'll come back to the compassion thing, any person or group based on race, ethnicity, gender, etc. So you talk about laws that are biased, you're right. There are biased laws, but I would suggest that the civil rights laws that govern public universities are not. They command non-discrimination against any person. Beyond that, I love what you said. I wish humanity could organize itself and live just according to compassion and harmony and so forth. I wish it were that way. But we've had to have civilization, we've had to have laws. We got to have laws. And so laws are no substitute for a good civil society. There has to be a good moral foundation underneath the laws. I agree with you. Go ahead.
There will be and the culture and the laws that are produced by this kind of a culture.
This kind of a culture.
The kind of culture that we promote humanity.
Okay. Kind of.
Could you repeat it then?
It's a concern about compassion and humanity. The thing is, when you got one job and 100 applicants, what do? You can be as compassionate as you want, but if you can't hire all 100, you're going to have to make some tough decisions, and you need some criteria or standards by which to judge, right? So I'm not saying that race or gender would never be legitimate considerations, even in governmental hiring in some situations, but as a rule, I think the civil rights laws got it right. Non-discrimination against any person. Because after all, nobody has any control what race or gender they are. So far as I can see, neither race, neither gender, no race has the market cornered on anything good or bad. I've seen women who are some of the best teachers I've ever seen. I've seen women who are some of the worst teachers I've ever seen. I can easily say the same thing about men, right? My view, I'm going to be 60 next year. So I've been looking at this stuff for a while. So far as I can tell, neither gender, no race has the market cornered on anything good or bad. Maybe it's because I'm a liberal, I'm coming at it that way, So I share your vision. I'm just not sure that those questions about humanity and compassion can help us sort this out. I would like to be as compassionate and humane as I can be, but if I'm working within an institution that in my judgment has long been secretly violating important laws that they say that they value, I don't think my compassion and humanity is going to get me out of that one. I got to make a tough decision. I must tell you, as you can probably tell, so far I have not been able to bring myself to do what my university does. I won't do it. I can't do it, right? A student who's studying with me, what has she done? Why should I do anything to her? I'm going to call it like I see it, right? The question is, if I were to wake up tomorrow and decide, you know what, to hell with it. I see how this game is played. It's what can you get away with for your tribe, for your gender, for your race. I'm going to do the same thing. I have every justification because, as Justice Brandeis said, if the government, for example, a public university, becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. They're inviting me to anarchy, in a sense. So, thank you so much. Somebody else? Other question? Right here, and then we'll get to the lady in the back. Yes.
Yeah, my question is regarding, you seem to raise two issues. One is the hiring process. In your consideration, that potentially may be not equal because they may hire a minority which, due to consideration of diversity, right, or due to consideration of equal opportunity for women. However, that, by reading you this, they said, well, the position open to all under condition fair, equal to opportunity, but second, that to be the greatest benefits to least advantaged member of society,
right,
which female, it is very...
I disagree.
Okay, we'll leave that.
I'll come back to it. Go ahead.
Second thinking is that university hiring, so they review hundreds of candidates' application. They get together and make a decision. From your point, from Adam's point of view, the male is more qualified. However, generally they may look at all those things. Qualifications, not just publication, not just research. There were many ways to look at teaching and personality, how you get along, how you're going to be a good role model for students, not just talk about. So if generally people consider that female is a better candidate, so I do not think that is discrimination. Second point I want to mention about when you write a recommendation letter for students, that's a different story because you write a recommendation based on their performance. So, under your eyes view, so equally, I would think you should provide recommendation in an equal way because that has no one else involved into your decision recommendation letter. That's my argument, comments, question.
Okay. Again, a lot of stuff there. I have to remember several questions at once. Okay. Again, this is hard to say things without offending people, but again, that's why people have tenure and academic freedom. I reject the claim that every woman is less privileged than every man. I simply reject that. There are men and women who have been enormously privileged in this life. There are women and men who have been enormously disadvantaged in this life. Most of us are somewhere in between, right? Yeah, so this idea that every woman has been disadvantaged compared to every man, from where I'm sitting, is absolutely false. Some women, some females have been born into very lucky circumstances, right? Relatively functional, well-to-do families that value education and hard work and really get them on the right, And there have been males who have been born into the opposite of that. I think what you're talking about is one group compared to another, right? Here's the problem. The civil rights laws don't talk about groups. The civil rights laws talk about any person, any individual. Now, remember, if you're unemployed, if somebody who of your gender gets a job, does that help you? It does not. The individual is not the group, and the group is not the individual. We have to make sure that we're clear about that. Statistics were mentioned before. If statistically people who look like me tend to have good jobs, but I'm unemployed, how does that statistic help me? The individual is not the group, and the group is not the individual. This is the core of liberalism in all its forms, and it is why the civil rights laws say what they do. They expressly protect the individual person. We may not like it, but every person is protected by the civil rights laws. Yeah. So, you mentioned other things like role model and so forth. I spoke to that a little bit before. I can say more about it a little bit later. But anyway, let me leave it there. Thank you, because I have one more question there.
Yeah, I guess I got the mic over here.
Oh, yeah, go ahead. Go ahead.
I was just going to mention
I want to make sure we also get to that lady back there.
I was just going to mention something I heard that I think LBJ said, which was if you have two people in a race and one of them, say, has shackles around their feet and the other doesn't, and they run half the race, and, the one without shackles is way ahead, then you take off the shackles and then you say, okay, now everything's equal, finish the race. So I think that's sort of the problem, is that people have been disadvantaged. And I think what you're talking about is one way to try to make up for the disadvantage. If, say, well, let's say the one with shackles won the race, and you're saying, I think that's wrong. And I think you could be right. But I guess what I'm wondering is, don't we also need to say we need to do something to make up for the fact that one of them had shackles, and send them to more remedial classes or something to help them, make up for the inequality?
Okay, okay. So once again, I would say it is inaccurate to suggest, and I don't think you were directly suggesting this, but I just want to be clear, to suggest that every woman has had shackles her whole life compared to every man. We just can't go there. Right? Okay. So that premise doesn't quite work. In terms of disadvantage, since you asked, another chapter of the book is called Rawls and Reparations. In fact, you're supposed to ask me I'll be glad to come and present that. In that chapter, I argue the following. From Rawls's principles, you cannot derive strong forms of affirmative action, but you can derive strong forms of legislative reparations directed at the least advantaged communities. So that's my answer. But that has to do with ethnicity. Specifically in the kind of areas that would tend to be least advantaged are not under a Rawlsian system defined simply by race or gender, but urban black communities and rural Native American communities are arguably among the least advantaged, and so they should be the beneficiaries of the different principles. So that's what I would do. But don't trash the civil rights laws. So, every person is protected under the civil rights laws. And again, not every woman is disadvantaged compared to every man. Show me otherwise. I just don't see it. Okay, go ahead. You're next.
So Martin,
yes.
Talking of fairness, I've been religiously taking people's hands as they go up, recognizing them and keeping an order.
Okay.
This lady was 10th and we're on number 7.
Oh, I'm sorry.
If you want to take that over and you want to do that.
Whatever you want to do. I want to be fair.
At the moment, I'm following that. And
equal basic liberty.
Is that fair?
Fair equality of opportunity. I'll stand here until I drop. I'll answer your questions.
Right.
Yes, hi.
Okay. So, of course, I'm sure, along with many other people in the room, as you were talking, and you were talking about gender discrimination, in the beginning of your talk, I was thinking he's talking about women being discriminated against. But when you started talking about your ex-colleagues justifying what they were doing by diversity, underrepresentation, and role modeling, I realized, in fact, you were talking about men being discriminated against, right? But those of us in the room probably were thinking you were talking about women, but in fact, you were deliberately used the word gender
yes.
to be, it could mean either And then when you started talking about justification, anyway, so that was very clever on your part. Using role models, I mean, your argument about social media is only really for the last few years. I mean, you go back 10, 20 years, and role models were not very available to underrepresented people. I've worked for 40 years to get more women into physics, and I can tell you that, you know, we had to bring role models to conferences where we brought the girls. The role models were not available in the media in general when you go back far enough. And that's, you know, we're looking at a historical point of view here. Lastly, I don't like the idea of university tenure. I don't see why people in university should, when the rest of us, we're all at will. We are all employed at will. We can be laid off at a moment's notice. And so this idea of academic freedom, you know, I don't think it really is a good argument for giving a very small portion of the universe the ability to have a job forever. And so especially maybe in political science, it's, you know, you being able to espouse your views and not be fired for it. Maybe political science, you could use that argument, but in regular science, you know, in physical science, in physics, that doesn't usually come up because one is trying to show things by experiment and data. Anyway, that's my say.
Okay, thank you so much. First of all, with respect to role models, I grant what you say, but again, you dated the argument yourself, right? I'm talking about right now in hiring, you know, students of both genders and many races don't have to look far to find role models that look like them. So I think what you're saying was true decades in the past, but now not so much with the rise of social media. Okay. Tenure. Okay. Here's the thing. It's hard for me to see why somebody would pursue a PhD in English and pursue a university teaching job unless there were not at least a chance of tenure, right? You take a PhD in English, or let's take philosophy, right? Both great disciplines, right? But if you don't have a chance of getting tenure such that you can take 10 years to get a PhD, get into a job, work there for 10 or 20 years, you're middle-aged, and suddenly somebody fires you, what else are you going to do? I mean, you've been doing that. It's kind of the nature of the work. You know, there's, in a sense, not much you're, you know, fit for besides that. Right? I used to be a lawyer, right? I could conceivably go back to practicing law, but after 25 years, I don't think so. So maybe if we were starting society from scratch, we wouldn't have tenure, but I think that there are good reasons. I think tenure does serve some important functions. I think you're underestimating the politics that go into academia. Right? There are people in positions of power in academia who would fire me like that for the things that I've said today. Right? So, yeah. So I think that tenure is, I've seen it abused. I'll grant you that. I've seen it abused, but anyway, that's not what we're here for. So that's right. As long as I can keep my tenure, I don't care what. No, I'm not. I'm just kidding. I'm just kidding. That's not true.
So,
that would not be consistent with the social contract.